Hi, this is Joseph Backholm with the Family Policy Institute of Washington with your weekly review for what's going on in Washington and around the country. Here in Washington State, we have emerged into another special session. And the stalemate continues into this week, and we really don't know when it's going to end. The situation is the Senate has passed a budget, and they are looking over at the House saying, hey, what are you going to do? And the House has not yet passed a budget. There's been budget proposals, but everybody's kind of just staring at each other. And it remains to be seen how long this is going to take. There's been some chatter of legislators who hope that maybe they will be out within a week, but we are not yet aware of significant movement that would make that, would let us know that that's going to happen for sure. So stay tuned. It does appear to be a standoff. Who's going to blink first? That is anyone's guess. Around the country, there has been some developments on the bathroom issue. As you know, we're debating that here in Washington State, but also in the state of North Carolina. The city of Charlotte had passed a bathroom ordinance that, similar to our rule, opened up bathrooms to people based on their gender expression or gender identity. But the state of North Carolina took action. They called a special session to deal with this rule, which was scheduled to go into effect on April 1st. And they wanted to act before the rule went into effect. And what they said is that this issue will be dealt with statewide, not at a city by city or county by county level. And this statewide rule is that bathrooms will be used based on people's actual gender, not their expressed or identified gender. And so that is a victory for those of us here in Washington who are working on this issue. Be of good cheer, because common sense is still having a say in the state of North Carolina. And of course that follows the vote that took place in the city of Houston last November, where by a 21 vote margin, they also repealed legislation that would have opened up bathrooms based on gender identity and gender expression. Another story getting headlines this week nationally is the Little Sisters of the Poor going to the U.S. Supreme Court. And they are there challenging a requirement that they sign an opt-out form in order to not provide controversial contraceptives to their employees. They don't want to provide the contraception. The federal government is saying, okay, if you just fill out this form, then we will come in and we will provide that for your employees on our own. But the argument that Little Sisters of the Poor and other plaintiffs are making is that if we fill out this form so that you can do that, we are essentially participating in the provision of what we believe to be immoral drugs to our employees. And the question ultimately for the Supreme Court is that a decision that the Little Sisters of the Poor get to make for themselves, or does the government get to come in and say, well, that's not really a violation of your religious beliefs because it's too attenuated? That's the issue. Arguments were made this week. It's an important religious freedom debate and case. Remains to be seen how the court will decide, but keep that issue in prayer and be aware of the implications, because as all of these religious freedom cases move around the state. Here locally, the bathroom initiative continues to move through the administrative process before petitions were created. It was in the code revisor's office. It moved to the Attorney General's office, who created a title and a brief description. But that title and brief description has been challenged by Just Want Privacy, the initiative campaign. There is concern that the title and description are both prejudicial against the ballot initiative, and the statute in the state requires that they be a neutral, not prejudicial description of the initiative language. And there's concern that the Attorney General has not quite met that duty. So next week, this will be argued in Superior Court in Thurston County, and ultimately a final ballot title will be created by the judge there in Thurston County. At which case, if the ballot title and description are adequate, then petitions would be created. But another initiative has been filed that does essentially the same thing, that's already kind of on the track. In the event that the title and concise description are not adequate, that there's a possibility that we would run through this course again. So stay tuned. Still need your involvement. At some point when this starts, we're going to need a lot of people to get involved in that effort and volunteer and contribute and become part of the team. So that's what's going on in Washington State this week. Feel free to reach out if you have any questions. Until next time, I'm Joseph Backholm with the Family Policy Institute.